So as I said, we want to discuss appeals first. Appeals in civil matters or civil cases. The last time we attempted to do that, but the network was really bad. So we couldn't do much. And by way of introduction, we noted that appeal is very important aspect of civil justice administration. The reason being that human beings, we are fallible in the sense that people can disagree or people can make mistakes regarding things. So therefore, if one court has rendered a decision or judgment which you disagree, it should be permissible for you to take it to another court called the appellate court to look at it. And that is why we say that appeal is a very important aspect. And the appellate jurisdiction of courts, that the appellate courts play several important functions. One, correction of errors committed by lower courts. The lower court made an error, either error of law or error in evaluation of evidence, applying the law to the evidence as the case may be, that be corrected. Two, development and clarification of legal principles. Maybe some legal principles may be uncertain and it might have been applied or stated wrongly by a lower court. So an appellate court will have the opportunity to clarify that. Then appellate jurisdiction also protects litigants against miscarriage of justice. If as a result of something strange done by a trial court, you have suffered injustice or miscarriage of justice, there should be a remedy, and that remedy lies in what? In an appeal. And also, the appellate jurisdiction enables superior courts to supervise inferior courts. Yes, we have judicial review, which is different. Judicial review is properly for supervision, but to an extent, in appeals to the superior court also exercise some form of supervision in that regard. So what is an appeal then? How shall we define an appeal? An appeal is a process by which a party is satisfied with the decision of a lower court, invokes the jurisdiction of a higher court or a superior court in court to review, reconsider, rehear, affirm, vary, or reverse the decision complained of. Now we talk about two courts. We said a lower court and then a superior court. But we are using it in relative sense because we have three appellate courts in Ghana. We have the Supreme Court, the Court of Appeal, and then the High Court. These are all appellate courts because they exercise some aspect of appellate jurisdiction. So, if someone is aggrieved by district court and circuit court, of course, circuit court, if it's a civil case, you go to the Court of Appeal. But the criminal, you go to the High Court. We're not doing criminal procedure, so that's not of interest to us. So if you are aggrieved by the district court, you go to the High Court. If you agree by the High Court, you go to the Court of Appeal. If you agree by the Court of Appeal, you go to the Supreme Court. Another point to note is that an appeal is a creature of statutes. It's a proposition which is well known to all lawyers and students of the law, that an appeal is a creature of statute. When we say that an appeal is a creature of statute, we simply mean that there is no automatic or natural right to appeal unless the Constitution or a statute expressly grants such a right. An appeal is not an inherent right, but it must be created by either the Constitution or a statute. There are plethora of authorities in that respect. Can just look at the case of San Dima now against Asangalisa. San Dima now. Uh, 1996, 97, Supreme Court of Ghana Law Report 302. Now at page 307, Aqua JSC, as he then was, he later became a Chief Justice. But when he was just a judge of Supreme Court, he said this quote, "Now, it must be appreciated that an appeal is a creature of statute. Where a right of appeal is conferred as of right, or with special leave, the right is to be exercised within the four corners of that statute and the relevant procedural regulation, as a court would not have jurisdiction to grant deviations outside parameters of that statute," unquote. So he was reinforcing the point that the right to appeal is always created by a particular law, be it a constitution or statute. And for that matter, when it is being activated, it must be done so strictly within the confinement of that particular law which created it. And that has certain implications. If timeline has been prescribed for bringing an appeal or for doing anything, and if you don't stick to that, a court cannot allow you to do anything which is not consistent with what the law which created the appeal says. So let's keep that in mind. So what are the courts of appellate jurisdiction? We've noted the Supreme Court. So if you look at Article 129 of the Constitution, the Supreme Court shall be the final court of what? Appeal. It hears appeal from the Court of Appeal. Then, of course, the same point is made in the Section 2 of the Courts Act at 459. The next appellate court is the Court of Appeal. If you look at Article 137, 1 of the Constitution, as well as Section 11 of Act 459, that of course, as the name suggests, the Court of Appeal, it has only one jurisdiction, appellate what? Jurisdiction. So it hears appeals from judgment or orders of the High Court, regional tribunals, or some specialized bodies. For example, when it comes to, let's say, the General Legal Council, the Explaining Committee of the General Legal Council, or when it comes to Medical and Dental Council, when they are giving decisions and you are aggrieved, you don't go to the High Court, you go to the Court of Appeal. So those are special statutes which has created certain. If you look at the current Legal Education Act, which has been passed and signed by the President recently, I think there's a tribunal which has been created to handle people's grievances against various decisions relating to education. And then if you are aggrieved by the appeals, over there, you go to the High Court. You don't go to the Court of Appeal, as it were. Then the High Court also exercises some appellate jurisdiction. So if you look at 141 of the Constitution, as well as Section 15 of the Courts Act 459, the High Court has appellate jurisdiction over district courts, the juvenile courts, then the circuit court in criminal matters, not civil matters. So let's remember all the time that where there's a civil case decided by the circuit court and you are dissatisfied, you don't appeal to the High Court, you appeal to the Court of Appeal. But if it's a criminal case, you go to the High Court before the Court of Appeal. So let's keep that in mind. Well, the district court has, if you like, a tiny, it's not even proper. When it comes to the Rent Act, remember the Rent Act, where the rent magistrate has made the rent control. They have made the determination and you agree. You can go to the district court. That is not important now. Now, let's talk about types of appeal. We have two types of appeal. What we call the final appeal and the interlocutory appeal. And related to final appeal and interlocutory appeal, what we call final orders or judgment and then interlocutory orders or interlocutory judgment. The distinction is very important because different rules may apply when it comes to the type of appeal. If it's an interlocutory appeal, the rules are different, particularly timelines and so on. And if it's a final appeal, so the rules are different. So and in some cases, to leave to appeal may or may not be required, depending upon the type. And that is why we need to know the distinction. Now, in terms of distinguishing a final and interlocutory orders, and for that matter, final appeal and then the interlocutory appeal, two principal approaches exist. What we call the nature of the application approach, and then the nature of the order approach. When we say the nature of the application approach, we are talking about if a motion or application is brought to a court, as whether that application is interlocutory or final. Depends upon how it is. That's what we mean by the nature of the application approach. And that is why in the case of Salaman against Warner, it's an English decision, 1891. The one killed me at 7:35. The English Court of Appeal decision. Lord Isha, who was master of the rules at the time, stated this, and I quote, "I conceive that an order is final only where it is made upon an application or other proceeding which must, whether such application or other proceeding fail or succeed, determine the action." So, under this nature of the application approach, the court examines the nature of the application brought before the court. If the application itself necessarily determines the entire action, that is, it disposes of the entire action, so that there's nothing left to be adjudicated between the parties. If it disposes of it, then the order to be made in the application is what? The final order. On the other hand, if the action continues regardless of the outcome, when the application is determined, then the case will still have to continue, regardless of how the application was determined, then the order from such an application is not the final order, but it is what? Interlocutory order. So an example would be an application for amendments in order 16, application for injunction, interlocutory injunction under what? Order 25. Application for stay of proceedings. Application for extension of what? Of time. All these applications, ordinarily speaking, will produce interlocutory orders. The reason being that when those applications are determined, the substantive action will still survive or will continue, isn't it? Now, the nature, we also have what they call like the nature of the order, as opposed to the nature of application. The nature of the order. Now, the nature of the order approach emerged from a case we called the Botsan against Otricham Urban District Council. Then after passing the exams, I'm sure what you have done, if you learn them well, that should be enough for you to pass the exam. But as I've told you, it's not just to pass the exam, you have to know the law. You're going to become lawyers, isn't it? Some of you are sitting there, they said, oh, my Lord, for me, all that I care about is how to get over this thing. The little one can see that. Yeah, so Boxan against Otricham Urban District Council. Those of you who know England, I think it's a bit close to Greater Manchester. In that case, Lord Iverson, that's the Chief Justice at the time, Lord Alverstone, this is how it's written, Alverstone. Lord Alverstone stated entirely, quote, does the judgment or order as made finally dispose of the rights of the parties? If it does, then it ought to be treated as a final order. But if it does not, it is then an interlocutory order. So here, the focus is not so much on the application, but on the effect of the order made. And that is why we call it the nature of the order approach, as opposed to the nature of what? The application approach. So the basic test or the central question is simply this. Does the order made finally determine the rights of the parties? So that there's no matter. If the answer is yes, the order is a final order. If the answer is no, it is what? Interlocutory order. Now, if you look at the case law in Ghana, our court gravitates towards what we call the nature of the order approach, instead of the nature of what? The application approach. There are a lot of cases which suggest that. For example, if you look at the old case, with the West Africa Court of Appeal case, from Incarious 2 against Kwajo. 1957, one West African Law Report 241. The West African or the WACA adopted the other approach, and the court held that an order dismissing an application without prejudice to bring in another action did not finally determine the rights of the parties and was therefore interlocutory. So the order dismissed the action, but the order said that this action is dismissed without prejudice to any other action. So if you look at the order so made, you notice that it still opens the windows to possibility of some other a matter to resolve. So look at the nature of the order, then it is interlocutory, but not a final. In the same vein, if you look at Justice Apalu, as he then was, in the case of State Gold Mining Corporation against Sisala. State Gold Mining Corporation against Sisala. 1971, 1 Ghana Law Report 359, followed the Incarious 2 decision, and also held that where an order does not finally determine the rights of the parties, particularly regarding damages, the order remains interlocutory. So if you like when we're dealing with the judgment in default of appearance and so on, remember that if it's not a liquidated claim, and then the person defaulted to file a defense or the appearance, as the case may be, and you go by application to obtain judgment, the order which will be made will still not address the quantum, isn't it? And for that matter, that order cannot be treated as final, to be interlocutory, as it were. The Supreme Court, in the case of Opoku against Aziz Company Limited, Opoku against Aziz Company Limited, 2001, 31, Ghana Monthly Judgment 62, the Supreme Court affirmed the order approach. The same vein, the case of Poma against Fosuhini is a case every student should read. Poma against Fosuhini. Poma against Fosuhini. The Supreme Court acknowledged the difficulties in applying the distinction, but still adhere to what we call the order approach rather than the nature of application approach. You may also want to look at the case of Republic versus High Court Accra, as parte State Housing Company Limited, number 2. Republic versus High Court Accra, as parte State Housing Company Limited, number 2, 2009, SC GLR 185. Chief Justice Wood explained, quote, a judgment or order which determines the principal matter in question is termed final, whilst an interlocutory order does not deal with the final rights of the parties. So the Supreme Court in that case made the point that an interlocutory order may arise before judgment or deal merely with procedure or regulate the working out of the rights already declared. So that is the interlocutory. You may also finally look at the case of Attorney General against Faro Atlantic. Attorney General against Faro Atlantic, a case which has been mentioned in other topics already. And look at the Justice Chum's opinion, where Chum JSC will make the point that a judgment is final because it puts an end to the action by making an award of redress to a party or discharges the other. the cases are all saying the same thing. So what are the essential characteristics of a final order? A final order or judgment finally determines the rights of the parties. That is, the court has conclusively pronounced upon the substantive rights in controversy. Who is right, who is wrong, or who has an interest in whatever is being contested, and who does not have an interest. So that is a conclusive pronouncement. Two, a final order or judgment ends the litigation. No substantial no claims remains to be determined by the court. Then three, a final order or judgment leaves nothing except enforcement. So when a final judgment is made, nothing needs to be done again. All that is left is the court proceeding with execution or what? Enforcement. So what are examples of final orders? Judgment after full trial. Judgment after full trial. Summary judgment. Dismissal of action on merits. You know, an action may be dismissed on the merit. Can you imagine a situation like that under the rules? You remember the rule which says that if there's an issue which can be set down separately for early determination, and they can dispose of the case. Which order says that? Which order? No. Yes. There's a rule. Please look at order 33 rule 5. Order 30, somebody should read it for us. Order 33 rule 5. Order 33 rule 5, where it appears to the court that the decision of any question or issue arising in any cause or matter and tried separately from the main cause or matter substantially disposes of the cause or matter or renders trial of the main cause or matter unnecessary, it may dismiss the cause or matter or make such other order or give such judgment as may be just. That is an example. Then final award of damages is also another example, especially where there has been earlier interlocutory judgment and the person comes to do what we call assessment of all damages. Remember assessment of damages after interlocutory judgment? Yes, somebody wanted to make intervention. Yes. Interlocutory judgment. No. Yes. Yes, summary judgment is a final judgment. Is the default judgment, which is not automatically final. Some are final. If it relates to liquidated claim. But then if it relates to unliquidated claim, you need to go through assessment to find out the exact quantum of how much is owed. Then that is not a yes. Then final consent judgment is also, you know how to call consent judgment? Well, there's a case, all right? You have a dispute, and somehow the party said that we don't need to go through the full gamut of litigation, the full crucible of trial. Let's sit down, reach our own agreement or compromise. We do that, and then reduce it into writing, call terms of settlement. You go and file it in the registry so that the judge will see it. And then once the judge ascertains that yes, it is true, the parties to the case have all freely signed this, the judge can say that I am adopting your agreement as a judgment. And we call that judgment consent what? Judgment. So consent judgment is adopted based upon agreement or terms of settlement filed by the parties. And that is also a final what? Judgment, because it's on the merits, as it were. Yes, ADR is an example. It may also not be a formal ADR. It may just be the parties on their own say that I want to settle on their own. They just sit down and make agreement, and if freely, nobody's forcing anybody, and it is true, they file it in the court. And when the court has ascertained that yes, it's a free act by both parties, the court will go ahead and give a judicial imprimatur so that it becomes a consent what? A judgment. What are the essential characteristics of an interlocutory order? If you look at essential characteristics of final order, an interlocutory order does not finally determine substantive right, as you have noted. The merits remain unresolved. So that is one thing. Interlocutory order is procedural or temporary. That is, relates to matters of procedure or relate to matters which are transient, which are not permanent. So we regulate proceedings pending final determination, as it were. Interlocutory orders keeps the action alive. Further proceedings remain pending. What are the examples? Interim injunction, interlocutory injunction. You know the difference between interim injunction and interlocutory injunction in terms of the 25 of CF 47. Can anybody tell us? For 10 days. Good. So where you go as party, the court grants you interim injunction. The maximum lifespan is what? 10 days. And then you are supposed to repeat on notice that if the court is satisfied that you are still entitled to grant, then that will be interlocutory what? Injunction. Interlocutory in the sense that it will remain pending until determination of the case itself. Assuming you have injunction as part of the reliefs which you are looking for in the substantive litigation. If in the end you are successful, the court will grant what we call perpetual what? Injunction. Stay of proceedings is also interlocutory. Stay of execution is also what? Interlocutory. Amendment of pleadings is interlocutory. Extension of time, interlocutory. Discovery orders. Remember discovery. Discovery orders. Remember discovery orders. Security for costs is also interlocutory. Leave to defend. Joinder applications. These are all interlocutory. Stay of execution, we say is what? It's interlocutory order. Are you convinced?
Stay of execution.
Yes. Yes.
Yes.
You are convinced the interlocutory order?
Yes.
Is stay of execution interlocutory or a final?
Okay.
Yeah. So we seem to have two camps. Okay, so team final. Then team interlocutory. Let's hear you. You thought I was going to say Team Bruni and then team legal. No. Yes. Interlocutory.
Yes.
Okay, and then those who say final. Yes. Yes. Final. But there was a forceful voice this side.
Yes.
But we cannot link it to any human being.
Yeah.
Okay, all right, that is fine. Default judgment. Is it final or interlocutory?
Before.
The judgment default of appearance, judgment default of the defense. Are you sure? You are wrong. I would say it depends. It is it. It depends.
If no defense, there is
Certain types may be
final.
final and others interlocutory. Okay. Okay, so at least we know the types of appeal. We know the interlocutory appeal, which relates to interlocutory what? Others. And then final appeal relates to final judgment or others. And as we said, the distinction is important because of the timelines. You notice very soon that the final judgment or final order, if you have to appeal, like the High Court judgment, you have 3 months. After that, another 3 months.
Okay.
Extension, then after that extension, 3 months, making 6 months. That will be the end. Interlocutory is always 21 days. It's the High Court. And then after that, you lose the right, isn't it? And if you look at the even order 51, if you want to appeal interlocutory decision of the district court, it's not automatic. You have to even seek leave from the district court, what? Itself. Then you go to the High Court and so on. Good. Notice of appeal. What is a notice of appeal? Appeal is commenced by filing a notice of what? Appeal. So if you are dealing with the appeal of high court judgments to the Court of Appeal, the relevant rules, the Court of Appeal rules CI 19, and Rule 8.1 will say that an appeal to the court shall be brought by notice of appeal. So just as in the trial court, the suit is commenced by filing writ, generally speaking, or some other modes, including the originating motion or not, or notice as the case may be. In the same vein, when it comes to appellate litigation, appeal commences by filing of what? Notice of appeal. And one thing we should note is that the notice of appeal is filed in the court below. When we say court below, that is a court ACO. The court ACO simply means the trial court. The court which actually made the order or judgment which is being appealed. So that is the court below. So you file the notice of appeal in that court. You don't go to the appellate court and file them. So let's note that. The fact that you're appealing a high court judgment to the Court of Appeal doesn't mean that you go and file the notice of appeal in the Court of Appeal. No. In the same vein, the fact that you appeal the district court decision or judgment does not mean that you go to the High Court and file the notice of appeal. You have to file the district court. The district court, that is the court below. So let's keep that in mind. So we can look at the case of Frimpong against Nyako. Frimpong against Nyako. 1998, 99, SCGLR 734. And also Rule A2 of CI 19. Now, content of notice of appeal, what should be contained in the notice of appeal? Yes. Rule 8.2. Rule 8, sub Rule 2. And the Court of Appeal rules, you don't use orders, you call them rules. It's the High Court that and the District Court that we use orders. But the Court of Appeal and the Supreme Court, we say rules. Content of notice of appeal, what must contain in the notice of appeal? The notice of appeal must contain the following. The grounds of appeal. The grounds of appeal simply means the reason why you are appealing or you are challenging the decision of the order. 2, it must also contain whether the appeal is against the whole or part of the judgment. Are you appealing against the entirety of the judgment or just a portion of it? It's not always the case that you have to appeal the entire judgment. It may well be that it's just an aspect of it you disagree, and then you have to point that particular aspect out. For example, you may probably agree with the judgment holding the defendant liable, but you probably disagree with the quantum of damages or compensation, which the court awarded, and you think that the court should have awarded more. So you are not challenging the court's conclusion that the defendant is actually liable to the plaintiff, but you are challenging the quantum of the compensation, as the case may be. Then 3, the notice of appeal must contain reliefs sought. What reliefs are you looking for? What reliefs are you looking for? That the judgment should be set aside or certain thing be given to you, that should be spelled out. 4, it must contain the names and addresses of affected parties. You see, mind you, the notice of appeal is serving equivalent or analogous function of a writ. Just as a writ in the trial, you provide the reliefs, the parties, and so on and so forth. The same vein, in the notice of appeal, which is commencing appeal, you have to tell us those parties who are affected by the appeal and how the addresses for serving them. All those will have to spelled out in the notice of the appeal. And again, number 5, particulars of misdirection or error in law. If you are complaining that there has been a misdirection in law, you need to actually spell those things out. Now, the grounds of appeal, let's say a few words about them. The grounds of appeal must be concise, precise, non-argumentative, and non-narrative. In other words, stating the ground of appeal is not you making arguments. Just state it so that we know in precise, direct form what the sense of your complaint is. There are a plethora of authorities on that. You can look at the case of Hotel Marjorie Y Limited. Hotel Marjorie Y Limited against Munyo. 2013, 2014, 2 SCGLR 1342. A vague ground is incompetent and liable to be struck out. If the ground is vague, in other words, it's not clear, it lacks clarity, we don't get a sense of the complaint you are making against the judgment of the decision, that is a vague ground that to be struck out. So see the case of Akolache against Great Commission Church. Akolache against Great Commission Church. 2013, 2015, through Ghana Law Report 842. Great Commission Church. Amendment of grounds is also permissible. So grounds may be amended, but with the leave of the court. Grounds may be amended with the leave of the court. So if you look at the Rule 8, Sub-Rule 8 of CI 19. So Rule 8.8 of CI 19 And also the case of Boateng against Oliver. Boateng against Oliver. 2013, 2015, two Ghana law report 730. Now let's talk about time for appeal, the timelines. Interlocutory appeals first. Interlocutory appeals must be filed within 21 days from the date of the decision. So if the decision was made today, you have 21 days from today. Look at the Rule 9.1 of CR19. Rule 9.1a of CR19. Now, it is important to note, and this is a very important rule, the 21-day period cannot be extended. So extension does not apply to the interlocutory appeal. If you are not able to file within 21 days, you've lost that right of appeal. This is a very strict jurisdictional limitation. Now, if you look at the Interpretation Act, particularly Section 44, subsection 3 of Interpretation Act 2007-92, the date of the decision is excluded from the computation. So the 21, if it's today, it will start from when? Tomorrow, yes.
It must be 21 today.
Yes. Now, what about final appeals? Appeals against final judgment must be filed within 3 months, as we have stated already, from the date of judgment. From the date of judgment. So see rule. Do you have the Interpretation Act? Do you have it? Well, you can bind it like this. You have the interpretation, your rules, evidence, cause act, and some of the reconstruction. So if we look at the Rule 9.1b, Rule 9.1b, that is 3 months for final judgment. Also look at the well-known case of Tindana against Chief of Defense Staff. Tindana against Chief of Defense Staff. 2011 2 SCGL 724. Now, the court may extend time for final appeals, as we have noted. So the first is 3 months. Let's suppose that for whatever reason, you are not able to file within the 3 months. You can make application for extension. So the application must be made not after the 6 months, but within the 6 months, as it were. As should be supported by affidavit, you must canvass good and substantial reasons. So anytime you are going to file application, let's get this thing right. Any application, in particular where discretion of the court is being elicited, it is pertinent that you are able to advance or canvass some substantial reasons which should convince the court to exercise the discretion in your favor. Don't just go and say that the appeal was supposed to be filed within 3 months. The 3 months have elapsed, and under the rules, I have to come to court for leave. So I have come. As if you have to give some reasonable a basis. So see the case of Okujato against Irani brothers. I'm sure you've read that in company law already, haven't you? Okuje 2 against Iranian brothers, 1975, 1 Ghana law report, 96. Also look at the case of Harley and Sons. Harley and Sons against Bank of Ghana. 2010, 2012, 2 Ghana law report, 559. Now, when it comes to appeal from the district court to the high court, the governing law is mainly, of course, the Courts Act applies to all, but the governing law mainly is Order 51 of CI 47. Order 51 of CI 47. I would like you to spend some time and read. It's not lengthy. And just use about 1 hour to 1 hour is even too much. Yeah, so if you look at Order 51 through 3, yes. Of CI 47, yes, somebody called, yes.
What would the contents of the notice of appeal? I point to. So whether you are against the whole part of
The judgment. You want to understand.
but I know that there will be a number of issues may be set out for revelation. But one, probably the first or second issue, you gave the last but one issue. So in the appeal, when you drop the last one and then knowing that automatically you get it, then you just appeal against the one or issue two.
Okay, good. When it comes to the judgment or the orders, we are not looking at the issues. We are looking at the conclusions of the court on the issues. So if you take a judgment, all the plenty talking, they're interesting, but they are not important as the final orders. The final orders are the heart of the judgment, but they want to understand why these orders. Then all the lengthy talk will try to help us to understand why those orders were made. But then when we take the judgment, we want to know the operative aspects, that which is having direct effect. We are going to look for the orders which were what? Which were made by the court. So the orders made by the court is what you are targeting. Are you challenging all of them, like the decision? Are you challenging all of them? Or you are challenging aspects? Yes.
In the criminal scenario, the final conduct will be there.
The conviction and sentence, conviction establishes liability, and then the sentence like the punishment, isn't it, to be determined. So the guilt, for this is not a criminal law class, so don't let me confuse students. Yeah, so in the criminal procedure, you must always establish whether the accused person is guilty or not, isn't it, the liability? When that is established, then what is left is the appropriate sentence. And that is why sometimes the case may be adjourned for sentence to be done later. But then you want to ask a question where the guilt or otherwise have been established, is that final or interlocutory? You want to bring the concept there?
Yeah,
Yes, because the point is about the charges against the person, is he guilty or not guilty? If the court says that yes, we have confirmed that you are guilty, there's nothing left to be determined as far as that guilt is concerned, isn't it? Yes. But maybe matters like bail and so on, those are interlocutory. But as I said, that's criminal law. It's not what we are discussing now. Okay, so I said that in terms of appeals from district court to the high court, let's look at order 51. And in terms of like the timeline, look at the route 3. We look at the route 3 of order 51. Quote, subject to route 4, a person wishing to appeal under section 21 of the court Act 1983-459 against a decision of the district court shall file a notice of appeal within 3 months from the date of the decision appeal against. So 3 months, just like the High Court to the Court of Appeal. Sub-route 2, a person wishing to appeal would leave under section 21(2) of the Court Act against an interlocutory order or a decision of a district court shall apply to the court below for leave within 14 days from the date of the order or the decision against which the leave to appeal is sought. So when it comes to interlocutory appeal, let's say that the district court, for example, refused application for amendment, which we took there, that's interlocutory, and want to appeal. Or let's say that in terms of admissibility during the trial, it made a ruling that a certain document as opposed to tender is not admissible. So it's excluded, as it were. No, it's not admissible, it's not admitted. It's interlocutory, you want to appeal it. Order 51(3)(2) is saying that you must seek leave. Of course, that is what the Court Act actually says. We look at the section 21(2) of the Court Act. You have your Court Act, don't you? Section 21(2). Section 21(2). Section 21(2) of the Court Act reads, and I quote, a person aggrieved by interlocutory order is made by community tribunal. Of course, these have been amended. The community tribunal here refers to the district court, the court, as amended. In a civil matter, may appeal against it to the High Court with the leave of the district court, and the High Court shall have jurisdiction to hear and determine the appeal. So 21(2) is saying that leave should be sought. And then the rules of court have come to provide the operational guidelines. Yes, that if you're appealing interlocutory order, you have 14 days when the decision was made to bring application for leave. And the application for leave should be brought before the court below, which is the district court. Now, when the district court, for example, refuses it, what can you do? And you repeat the application at where? You repeat it. Yes. So if you look at the order 51 route 3, sub-route 3, where the court below refuses, that is the district court, refuses to grant leave, the person wishing to appeal may apply to the court for leave. Look at something. When you're reading the Court of Appeal rules, the Supreme Court rules, you see the same thing, so pay attention. The court, one is written small, one is written capital. Look at your law. That's why I said you must always have your law. Open your law and look at your law. On this occasion, don't look at me, look at the law.
Yes.
Look at the law.
The first one is written.
Look, I want to show you something. That's what I'm saying. Look at the law. Unless you look at it, you wouldn't see what I'm referring to. So order 51, route 3, sub rule 3. So let's look at it. Let's start. Where the court, you notice that that first court, the C is small c, isn't it?
Yes.
Where the court below refuses to grant leave, the person wishing to appeal may apply to the court. And the second court is capital C, like the big C, isn't it? For leave within 14 days from the date upon which the court below refuses to grant the leave. So the court with the big C or the capital C refers to the appellate court. And in this context is the high court. And then the small court refers to the court below. In the same vein, yes. As a typo. Yes, I like your ingenuity. But but that is what it is. Yeah, that's what it is. Is and this thing, if we had the time, if you look at the CI 19, what is the Court of Appeal rules? And if you look at the CI system, which is Supreme Court rules, you see the same trend. So let's say that in the Court of Appeal rules, when it says the small court, the C, it refers to the court below, in this case, the High Court. And then we just say like the court. That is the Court of Appeal. Now, when you are dealing with the court, Supreme Court rules, and then say like the court, you see small, that refers to the Court of Appeal. And then the big C refers to what? The Supreme Court. So that is how it is. So we know the timelines now. Well, there's also what we call like the cross appeals. Cross appeals. So at this stage, I'm just combining both appeal in the Court of Appeal, the High Court, and everything together. But they're all similar. Then where we need to point to the specifics, then I'll tell you. So cross appeals and variation. So when we say variation, notice of variation, if you look at the Court of Appeal rules, CI 15, for example, a person who has obtained judgment may not be 100% satisfied with the judgment. You may want an aspect of the judgment to be varied. So if you want an aspect of the judgment to be varied, you don't need to appeal. You don't need to appeal. So you file what a notice of what? Variation. So notice of intention to seek variation. You are seeking an order of the court to vary an aspect of what? Of the judgment. So later on, I mean, when you are practicing, you look at the Rule 15. And look at the case of Dodu and Adomako. Dodu and Adomako. 2012, one Supreme Court Ghana Law Report, 198. So what is the basic distinction between variation of a judgment and a cross appeal? Basically, in variation, where a party is seeking variation of a judgment, that is the respondent. That is the party who won in the court below. Is the respondent. And another party appealing forward. The appellant, isn't it? So the respondent, who is the victorious party in the court below, who is seeking variation, substantially supports the judgment, but seek modifications. He agrees with the judgment, except that he wants certain aspects to be what? Be modified. But when it comes to cross appeal, if a respondent is making a cross appeal, which is equivalent of a defendant making a counter claim. So a cross appeal is attacking the judgment independently. So the respondent won, but he's still attacking the judgment. It's also possible to have what we call the preliminary objection as part of the appeal. So if they are respondents, instead of course, if you are doing like that, in the court below the trial stage, we have what we call conditional what? Appearance. And I go by motion to either challenge the rate or service of it and so on. Equivalent concept, we have to call the preliminary objection. A respondent, that is the person against whom the appeal has been brought, may challenge the competency of the appeal, may say that the appeal is not competent. And the competency of the appeal here, for example, relates to maybe the fact that the appeal is out of time. There are straight timelines, isn't it? And if you don't calculate well, so if you're a respondent and you receive a notice of appeal, you have to find out when was the judgment given? What type of appeal is this? If it's a final appeal, you know the timelines, you calculate to find out the date of filing the appeal, which will be stated on it. And then when the judgment is given, if you do the calculation, as if fall within the timeline. If it does not, there is no competence. An appeal court, that's what you're doing all the time. When we get the records, before we worry our heads to do anything, we do the calculation. If it's even by 1 day, you're out, you know, you're out. Because it's like we're wasting our time and energy because our jurisdiction has not properly been what? Invoked. Or there may be some procedural defense, so that may be the basis of the. So if you look at the rule 16 of CNN, you can read it later on. Yes.
The cross appeal and then the variation of appeal.
Yes.
You will need to attack the appeal itself before you seek to vary it.
No, usually.
You need to attack the judgment before you seek to vary it.
No, there is a cross appeal. It's where you are disagreeing completely with the judgment. But the variation, you agree with the judgment. It may well be that maybe you think that previously they used what they call the review. The High Court used to have the power of review. So instead of appealing, you can go before the court and draw the court's attention that XYZ should be reconsidered. And for that matter, but now that review has been taken out. So you cannot go to the High Court for the review, but you can still achieve that, for example, through variation, as the case may be. A record of appeal, let's say a few things about that. Yes. For example, let's say that this is about award of damages, and you think that, yes, the judge stated the law correctly, but then the application was not properly done. And for that matter, what was actually awarded, you think should have been what? Different. Or a certain, if it's about interest calculation, then a certain components of items shouldn't have been included, as the case may be. So all those may be some of the ways, yes. Or even sometimes costs. It may well be that a cost was awarded in your favor, but you think that, and we'll be discussing costs, we've discussed it already, but we'll discuss it again on the 74. You think that, having regard to the complexity, the length of the litigation, everything, you are giving a cost of not less than 100,000 Ghana cedis. And maybe you're giving something like a 20,000 Ghana cedis. So here, you don't disagree that you'll be giving costs, but you think that the cost you are giving should be escalated to a certain preferred quantum, isn't it?
There's like the Daniel Fourier and the Ecomark. The Daniel Fourier and the Ecomark case. I think the judgment was given very recently.
Yeah, there are a lot of them, but I haven't followed.
I think Daniel Fourier went to court challenging the calculation of the interest by Ecomark. So the case went through appeal and finally it was disposed of. That the percentage that was used to calculate the interest on his shares should be varied. And because of that, it won a 29 billion.
Yeah.
Citizens.
Yeah. Yeah, I think there's a similar case between Infolax and then one of the ministries. sitting as additional High Court judge, I gave a judgment in favor of the Infolax. But then later on, they came back that the aspect of the calculation they think was inaccurate. So we should be looked at. So they argued, we look at it closely and realize that if we are to do what they are asking, it will sort of a sitting in an appeal on our own judgment, which is not permissible. If you want to, what they call the slip rule. Remember the slip rule? The slip rule under what? Hello? Order. The slip rule. Hey. The slip rule. Order 16. Clerical what? Clerical, yes. So that was a very strict organization, but that wasn't it. Okay, let's move on. Record of appeal, very important. Record of appeal. The record of appeal is very important. If you look at the order 51 7, look at order 51 7. The court below shall make up the record of appeal, which shall consist of, so defining what the record of appeal is. Order 51, I'm talking about CR 47 now. Order 51 7. The court below shall make up the record of appeal, which shall consist of the originating process, the pleadings, if any, certified copies of all documents admitted as evidence or tendered as evidence and rejected, the notes of evidence, any interlocutory proceedings or orders, judgment or orders of the court below, the notice of appeal, and the address of the parties or their lawyers or both. So when we say the record of appeal, that is what the appellate court is going to look at. And it's made up of the entirety of, first of all, what the parties have agreed to form part. So there's something called the settlement of record. The parties, especially when it comes to the court of appeal practice, appealing the High Court decision to the court of appeal. There was called the settlement of what? Record. The party will have to settle records, meaning that they'll go and meet the registrar and agree regarding processes and documents which will be compiled together to form the record of appeal. But in terms of appealing a district court decision, Order 51 7 is saying that so unlike no other here, there's nothing really like a settlement of record. Once you file the appeal, automatically certain things are supposed to go in as part of the record. The originating process, the rates, if pleadings are ordered. The district court is not all the time that pleadings are ordered. Unlike the circuit and the High Court, where it's automatic. But the district court is a court of summary jurisdiction. So being a court of summary jurisdiction, once the rates have been issued, the court can, even on the first day when you appear, the court can start dealing with hearing the matter. It is only where the magistrate is on the view that having regard to the matter, there's some complexity. So the parties should be given the opportunity to fully set out their case, in the formal pleadings, so that the issues in controversy will be narrowed. Then the court will order pleadings. Other than that, in the district court, being a court of summary jurisdiction, is not mandatory for pleadings to always to be done. But evidence in the form of witness statements, various exhibits which were rejected. So during the trial, if you remember, where somebody seeks to tender something and is rejected, it is marked as R. So maybe R1. If another thing is rejected again, R2, R3. Despite the fact that it was rejected, it will still form part of the record. Because the appellate court will have to decide whether the trial court was right in rejecting admissibility of such a particular exhibit. And it may well be that because a certain exhibit was rejected, that is why a certain decision was arrived at. Meaning that if that exhibit had been included, it would have had a very telling effect on the judgment, and everything would have what? Changed, isn't it? So the registrar settled the record with the parties. Look at the case of a West Lowry Company Limited against ADB. West Lowry. Lowry.
Well,
Yes.
yes. In the case as a party introducing evidence that was not available to them.
Fresh evidence on appeal.
Yes, on appeal. It's not automatic that the Court of Appeal would allow that party to put that evidence before them, or the court has that discretion to assess the evidence first to determine whether it will even be appropriate for them to give them the opportunity to bring that evidence for the court.
Okay, good. Now, fresh evidence on appeal is a very restricted, practice. It's not common. For almost 4 years that I've been sitting in the Court of Appeal, I haven't come across more than one instance. There was even one criminal case, a case involving the girl who fought someone, the Tamale, over a boyfriend, Zela, yes. Even that one was not properly done. If you read the judgments we give about like the age of the accused person. Yeah. Yes. Yes.
I see that I say that I see that I didn't want a lot of price.
Yes.
Now the right and then open for the practice and the platform practice these records.
Oh, good. Good. So so just before I come, let me finish. So the point I'm making is that fresh evidence on appeal is not impermissible, but it's not common. It's not impermissible. That notwithstanding, the practice of its admission is really an inflexible rule, not an inflexible, it's strict. The evidence might be said that with diligent effort, it wasn't available. Then, if it was available at the time, then but with diligent effort, it couldn't have been available, and then it's available. And it's so fundamental that if it had been discovered, the fate of the case will have been completely what? Different. So there's a high threshold which will have to be met before such fresh evidence will be tolerated on appeal. So it's not common. Now let's come back to him. He said that all the things judges write, do they form part of the record of appeal? With respect to the judgments and then the rulings, yes, they do. So if the judgment is even 100 pages and you're appealing, of course, when you're appealing, the core aspect of your complaint is that you disagree with the judgment, isn't it? So the judgment automatically should form part. And then other things, the pleadings, the various evidence, including rejected evidence, and then the written address. At the end of the trials, remember, the lawyers will file their written addresses, and they will also form part. Because you'll notice that appeal is by way of rehearing. rehearing in the sense that the appellate court is putting itself in the shoes of the trial court to look at everything which is on record and find out if what the trial court, the conclusion it came to, is it supported by the record available, or the conclusion it came to is at variance with the record. Yes.
The next part of the question is that there are a lot of things that you guys want reviewing and they're open to the file and the councils if they want to.
Oh, good. If you look at the course act, if you look at this before, and I have cited it in this class, I think section 69 and 70 of the course act. You have at 459. What do you call the record of the court proceedings? The court proceedings, the official record. Yeah, so you can start from good. Section 69, record of proceedings before a court. So I'm talking about the court start at 459. Section 70, access to the record of court. So section 70 says that, quote, no person is entitled to inspect or have a copy, the record of evidence in a case before a court, or to a copy of the court's note, except as may be expressly provided by the Constitution, a rule of court, or any other enactment. 72. If a person affected by a judgment or a court desires to have a copy of the judgment, order, the position, or other part of the record, he shall, on application for the copy, be furnished with it if he pays its cost, except where the court, for some special reason, finds fit to furnish it for free. So, the court is a public thing. So, if you are affected by it, if you are affected by a judgment or proceedings in the court, you put in a request. You'll be made to pay the fee for like producing and the printing, but then it will be given to you. And in fact, as you become a lawyer, my advice to you is that a good practice in law practice is that when you go to court, after every court session, request for record of proceedings and keep it on the file which you have. That's very important. Just as when you come to election, protecting the ballot, you remember that. Protecting the ballot. So when it comes to litigation, you need to protect the record. You need to protect the record. Anything can happen. It's on computer. The computer of the court can crash, isn't it? There can be fire. Just imagine all manner of scenarios. And judges too don't stay at one court forever. There are some cases when you are dealing with it, you go through the file, you notice that about 6 judges have sat in that court, some aspect of it. So, if you are a party and you don't have an accurate, up-to-date record, if something goes wrong, you will suffer, isn't it?
My time to talk, take your own notes.
Yeah.
So
good. So a lawyer, you take your notes, but this is something called the DTS, the direct transcription system. Some of the course you will see computers over there. Whatever is going on is being typed, you see it on the screen. Yes, so you have to monitor the screen to make sure that it's captured properly. And if you have your own record, you use a record to cross-check. If you go and cross-check and there's some discrepancy, you bring a motion and bring it to the attention of the court. I think that the minutes of this day's proceedings is not accurate. And then the court will look into it. And then the necessary corrections will be made. A lot of lawyers, they don't pay attention to this. And will just be doing the case. Meanwhile, sometimes, if mistakenly not is inserted in evidence, it can change everything, isn't it? Or if there should be not, and then it's omitted, it can change everything. So you need to be very meticulous, and vigilant. In any case, it's your case. The court doesn't have any interest. You have an interest in it, isn't it? You have to make sure that the thing is properly what? Yes. We also have what they call the security for cost as part of appeal. Security for cost. So if you look at the 51, talking about appealing the district court decisions, the Court of Appeals, for example. Order 51, that is a USIS, deposit or security. The appellant shall within 1 month after being notified by the registrar of the court below to do so, deposit in the court below the prescribed fee to cover the expenses of making up and forwarding the record of appeal, and shall also deposit a prescribed sum or give security by bond within one or more sureties to the satisfaction of the court below for the due prosecution of the appeal, for the payment of any cost which the appellant may be ordered to pay. Order 51 says so, while the appellant first comply with sub-rule 1, his appeal shall lapse unless the court grants extension of time within which to comply with this rule. 3, an application for extension of time under sub-rule 2 shall be made no later than 1 month after expiration of the period specified in the rule 1. So the deposit or the security for costs, this is how it works out. An appeal is not a joke. If you are an appellant, you must show seriousness. And your seriousness is tested by the preparedness to bear the basic costs regarding preparation of the record of appeal. The respondent is not appealing, you are appealing, isn't it? The record will have to be prepared. You put them together like a book. Then you have to make copies. If you ask for high court, it's not really, maybe maximum. They make about probably 4 copies. Because one will be for the high court, and probably 1 extra will be kept. And then the parties, if there are 2, will be given copies each. If it's the court of appeal, you have to make about, the judges are 3, plus let's say the parties, and maybe like an extra 1. So sometimes about 8 copies or something like that, as the case may be. And some of them are, yes, sometimes there's some cases we do the appeal volume, sometimes about 24 or 25 volumes, meaning that 1, 2, 3, 25. So just imagine you have to do 8 copies of each of the 25. It's expensive, isn't it? So the registrar will compute the expenses involved, and then it's brought to your attention. You have time within which you have to pay. If you don't pay and you don't go for extension, then your appeal will die there. It will not go further, as it were. Sometimes too, it's not only the cost of preparation. Also, it's gone off, eh? You can hear me. I have a loud battery. Something. Yeah, thing is working. Yeah, so sometimes it's not only just the cost of preparing the record. There's also what they call the security for for costs. What do you mean by that? You've lost the case. You want to appeal. The respondent may have to engage lawyers, may have to do so many things to fight the appeal back. Now, if at the end of the appeal, you lose again, and then the court has awarded costs against you, how do we get the money? So, for example, you may be asked to deposit a bond or make some security arrangement to assure us that should you lose the appeal and then the cost will be paid, you have the requisite means to do what? To pay it, as it were. Security for costs. It may be done if it's ordered. It will have to comply with. But the what do you call the pay, paying the appeal, the money you have to the prescribed fee. That one is always mandatory. Otherwise, the record cannot be prepared and transmitted. Also, look at the case of Abe Yevu against Okansi. Abe Yevu against Okansi. Abe Yevu against Okansi, 2009, SCGL 703. Abe Yevu against Okansi. Don't ask me how to spell Abe Yevu. Don't ask me, you know why? Many years ago, I did 1997, 98, when I used to be a student with Professor Kumado at the University of Ghana Law Faculty. When he was teaching us, he will mention, the cases, and maybe like those of us who are listeners, maybe it's only the three that we know how to speak or write. Some names are mentioned, and people will be asking him to write it on the board. And he says that his little contribution towards national building and national development is to encourage people to learn other people's names. So my little contribution towards national cohesion is to get you to learn others' names. So Abe Yevu and Okansi, 2009, I'm not writing it on the board. If it's a Chinese or Japanese name, I'll write it because it's not a Ghanaian name. But all the Ghanaian names, you have to learn each other's name. That's the little you can do. Yes, 2009 SCGLL 703. But I think in the district courts, yes. Where? No, it's not, please. I'm not helping you. It's Abe Yevu against Okansi.
Because in the
2009 SCGLL 703. I finished. Okay. Now let's say a few things about written submissions. But before written submissions, going back to the question our friend asked about the fresh evidence on an appeal. Speaking specifically about appeals from the district court to the high court, I want us to quickly look at Order 51 Rule 13. Order 51 Rule 13. Order 51 Rule 13 of CF 47. It is not open as of right to any party to an appeal to adduce new evidence in support of the party's original case. But for the furtherance of justice, the court may allow or require new evidence to be adduced, and the evidence shall be either by oral examination in court, or by affidavit, or by deposition taken before an examining commissioner, as the court may direct. But the new evidence, shall be evidence which was not within. So this is the critical test. The new evidence shall be evidence which was not within the knowledge of the party, or could not have been produced after exercise of due diligence by the party at the time when the judgment was given or that order made. So for example, let's come to Lumba's case. What is the name? Odobroni and then what? Sewa. I think the case turned on the marriage certificate, isn't it? So can you later say that it's not that you discovered the death or you can't, so that's the kind of thing on the 51 no, Rule 13 is talking about. Now let's come back to the written submission. Written submissions. No, the appellant's written submission must be filed within 21 days. If we are talking about appeal from the High Court, the Court of Appeal, there's something we call Civil Form 6 under CI 19. We go to the Court of Appeal, we hear these things often, Civil Form 6. The Civil Form 6 is very important. When the record of appeal has been compiled and everything is ready, the records are transmitted to the Court of Appeal registry. And then when so transmitted to, copies will be given to the parties. And it will be accompanied by a form called Civil Form 6. So the Civil Form 6 signifies the transmission, that is, moving the record from the court below to the appellate court. And then from that time onwards, the appellate court will be fully seized, and everything concerning the appeal will have to be done from the appellate court and no longer from the court below, as it were. So if you look at the district court contest, 51 Rule 8, and still look at order 51 Rule 8, time limit for submitting record. It is a duty of the court below to ensure that the completed record of appeal and all associated documents specified in Rule 7.2 are submitted to the court's capital court, that is appellate court, as soon as possible, in any event, not later than 30 days after provisions of Rule 6 have been complied with. So, Rule 6, if you remember, that is where the appellant is told how much he's supposed to pay towards the creation of the record. So when that has been complied with, then within 30 days, the record is supposed to be forwarded or transmitted to the High Court. And it will be accompanied by what they call the mother docket. The mother docket simply refers to the docket. When we say a docket, it's simply a file. Okay? It's just simply a file. So if you go to the court, every case has a file, which we call like the docket. So all the things which are filed by the parties, the court copies are placed on the docket. So when appeal record is produced, it is the things on the docket which will be photocopied and used to make the record together with the exhibits. But then this original or the mother docket will also accompany them to the appellate court. Then to be kept for verifying things if necessary. Yes.
That is for the cost of record of proceedings for the respondent.
And the appellant?
The appellant.
Yes.
Paying for the cost of the record of. Does he also pay for the copy now be given to the respondent, or the respondent's pay for the cost? After the record of proceedings has been compiled,
yes,
you are asked to pay a fee for a copy.
Yeah.
I'm asking whether the appellant will pay for himself and then that of the
Okay, good.
respondent.
Well, the respondent may have to pay to get the copy, but that will be something which will go into the cost should the appeal be lost. If the respondent prevails over the appellant, cost will be awarded. But to let the whole thing be produced, is the appellant who have to pay, especially if there's no cross appeal. Because the respondent is not making, you are saying that to appeal it. So if you're appealing, you should prepare to bear the administrative cost for the process to move on. Yes.
It's Rule 6. Rule 6.
Rule
That
6.
talks about the deposits.
Yes.
It's supposed to be done within 30 days. Yes, maybe not later than 30 days. And when you read 8,
Okay.
it also talks about the fact that the transmission should not be done no later than 30 days or as soon as possible. Okay, so the question is, under Rule 6, within the 30 days, would the court wait for the 30 days to elapse? Or maybe 10 or 15 or 12 days into the 30 days, the deposit was paid, and then the notice by the notice has been brought to the court that the deposit has been paid. Would you have to wait for the entire 30 days to elapse before transmitting under Rule 8?
No. So if you look at the Rule 8, you see the ending part of Rule 8 said that and in any event, not later than 30 days after provision of Rule 6 have been complied with. So the worst case scenario, if Rule 6, you have 30 days to do the deposit and the security, that will run out. Then maximum 30 days after that, that's the maximum period. If you look at the Rule 8, then the record is supposed to be transmitted to the, let's say, the High Court under Order 51. Yeah, so usually written submission will be ordered for the parties to file. In the Court of Appeal, usually have 21 days. The appellant, you have 21 days when you are served with the same Form 6 before the written submission. And then when it is served on the respondent after being served also has 21 days. Now, if you are still even by 1 day, it's out. So if you go to Court of Appeal, then you spend a lot of time arguing with the lawyers, doing calculation, and then 1 day it's out, then we strike it out. And then we have to go and come back properly, as it were. Yes, I think on the fresh evidence we're talking about, you may want to look at these two cases. Foley against Ejata. Foley against Ejata. The general rule is that fresh evidence is not allowed. Foley against Ejata, 1976. 1 Ghana Law Report 194. And then Kakari against Wiafe. Kakari against Wiafe. Interestingly, Kakari is always written Kari, but we say Kakari against Wiafe. 1982-83, JLL 864. And then conditions for the fresh evidence of what we discussed, but just to give you the full context. So fresh evidence will be admitted where 1, the evidence is unavailable at trial despite diligence. 2, is relevant and material, as we've explained. 3, it is credible. And 4, likely to affect the outcome, meaning that if it's admitted, it may result in the outcome change. If these conditions are met, then fresh evidence will be admitted. So let's look at the case of Poku and Poku. Poku and Poku, 2007-2008, Supreme Court of Ghana Law Report 996. Then let's look at the English decision. Scone and Scone. S-K-O-N-E. That one is not a Ghanaian language, so I will spell it for you. S-K-O-N-E. Scone and Scone. I'm going fast. Oh, okay. Kari and Biafin. That is 1982-83. JLL 864. And I also mentioned the case of Scone and Scone. 1971, 2-all England Law Report, 2-all ER 582. 2-all ER 582. And there's this criminal case which provides some insight. Azamachi against the Republic. Azamachi, you're familiar with it? Good. Azamachi against the Republic. 1974, 1 GLR 228. Okay, so let's say a few things about the hearing and determination of appeals. When it comes to appeals, of course, the Court of Appeal, you know, 3 justices will sit. And what the court will do is that the court will adopt the record, consider written submission. In practice, those of you who go to the Court of Appeal, when the lawyers are called to argue the appeal, you say that, my lords, I'm relying on the written submission we filed on so and so and so. We have nothing more to add. Then the court will adopt that. Or, since filing it, if you've come across maybe some authorities which you didn't include and you think that are important, you can say that you have this additional thing you are relying on, then the court will take note of it. The respondent also will do the same thing. What are the powers of the courts in hearing the appeal? If you are dealing with we come to the High Court very soon in terms of Order 51 Rule 14. But before Order 51 Rule 14, if we take the Court of Appeal, CI 19, Rule 32. Rule 32, when the Court of Appeal is hearing appeal, it has the power to affirm, reverse, vary, substitute, or make any order which the trial court ought to have made. So look at the Rule 32 of CI 19 and also Article 137, Clause 3 of the 1992 Constitution. Now, in the same vein, when it comes to the High Court, dealing with the appeal from the District Court, Order 51, Rule 14 of CI 47 says that, Order 51, Rule 14 says that, quote, the court may, in any appeal before it, rehear the whole case. So rehear, when we say rehear, what does it mean? Rehear does not mean that the court is going to call the witnesses to come and testify. No. So when we say appeals by way of rehearing, it doesn't mean that the court is going to replay the trial. No. Everything has been captured in writing, and what we call the record of what? Appeal. So the appellate court is going to examine the full spectrum of the record to find out whether it agrees, not that it agrees, whether the decision or the conclusions of the court below, whether they are justified by the record, whether they are supported by the record. That is the rehearing. The appellate court may even disagree, but this mere disagreement is not enough. The conclusions of the court below, are those conclusions supported by the record? If they are supported by the record, but then some other view could be held, you cannot interfere with what the court below did. So rehear the whole case, or may remit it to the court below to be reheard. So remit it to the court below to be reheard means that there's going to be retrial, as it were. And circumstances may occur. Let's suppose that if you remember Order 36, maybe the case was called and the defendant was absent. So judgment was entered in favor of what? Of the plaintiff. The plaintiff did not come within the defendant did not come within the time permitted for setting aside the judgment entered in his absence. And then the court says that I'm not going to set it aside. Then appeal is made against the refusal to set it aside. And let's say the appellate court becomes convinced that no, this was a deserving case for the court below to have actually set aside the judgment given in absence of this defendant, and then for the case to be heard on the merits. Assuming the appellate court is so convinced, it can say that that judgment of the court below, given in absence of the defendant, has been set aside, and then the court below is ordered, or the matter is remitted to the court below for it to be heard on the merits. Do you understand? So now there's going to be an actual hearing on the merits.
By same judge.
It can be the same judge. Uh, 14 again, or direct the court below to inquire into and certify its finding on any question which the court considers fit to determine before final judgment in appeal. So when there's a matter before the appellate court, sometimes certain things may need to be ascertained before it can deal with it. They can send it back to the court below for them to do certain things. C, allow the appellant to amend the grounds of appeal, or may itself amend the grounds of appeal, and may amend any defect or error in the record of appeal. D, draw any inference of fact which should have been drawn in the course or matter out of which the appeal arose. E, make any order on such terms as is considered just to ensure determination on the merits of the rare question in controversy between the parties. F, make any interim order or grant any injunction which the court below is authorized to make or grant, and may direct any necessary inquiries or accounts to be made or taken, and generally shall have as full jurisdiction over the whole proceedings, as if the proceedings have been instituted and prosecuted in the court as a court of first instance. J, give any judgment or make any order that ought to have been made, and make such further or other orders as the case may require, including any order as to cause, and may do so notwithstanding that the appellant may have asked that a part only of a decision be reversed or varied, and may also act in favor of all or any of the respondent or parties, although the respondent or parties may not have appealed from or complained of the decision. In such special circumstances, order that such security be given for cause of appeal as may be just. So these are some of the powers which the High Court, in exercising its appellate jurisdiction over the decision from the district court, may exercise. Delivery of judgment. Yes. Yes, the Court of Appeal, that's Order 30, what's called the Rule 32. Rule 32 of CR19 is equivalent or largely empowered material, as it were. Yes. Okay, so application has been argued. I've adjourned for ruling, so I'll give my ruling very soon. Okay, so we'll finish before, just a point, and then when you come back, we'll talk about the sale of execution and so of proceedings. And then, yeah, so time for delivery of judgments. When the appeal has been heard, the Court of Appeal judgments will have to be given within 8 weeks after close of the case. Within 8 weeks after the close of the case, judgments will have to be given. 8 weeks, which is about 2 months. Okay, so let's have our break. Let's have just a 5 minutes break. Okay, so welcome back. So just before we finish our discussion on the bill, I think there's one important aspect which we need to be familiar with. Stay of execution, then stay of proceedings. So first, let's deal with the stay of proceedings. A stay of proceedings is an order halting ongoing proceeding in a court pending determination of an appeal or some other matter. So if you look at the Atkins Encyclopedia of Court Forms, which you have in the library, to define a civil proceeding as follows, and I quote, Atkins Encyclopedia of Court Forms, quote, a stay of proceedings arises when under an order of the court, proceedings which are pending in that court are brought to a halt at the stage which they have reached, so that while the stay is in operation, the parties are precluded from taking any further step in the proceedings, unquote. So, if stay of proceedings, for example, is successful, is granted, the trial proceedings stop or is put on hold. The parties cannot take any further steps, or the matter is frozen pending appellate determination. And particularly, stay of proceedings is relevant where you are doing interlocutory appeal. The stay of proceeding becomes relevant where you are doing interlocutory what? Appeal. And if you look at the authorities, the courts repeatedly describe stay of proceeding as a serious remedy or exceptional remedy or a drastic interruption of litigation. It's not something which is done lightly. Now, what is the source of the court's power to grant stay of proceedings? There are three sources. If you look at the Supreme Court decision in Zik Puzo Apachu Fenu, Zik Puzo, one name, and then Apachu, one name, and Fenu, and four others. Don't ask me how to spell. As part of Ghanaian integration, we have to know each other's language. You don't only have to intermarry, you have to also learn each other's languages. Yes. So, Zik Puzo, Apachu, Fenu, and four others against Attorney General and three others. 2019, Volume 130, Ghana Monthly Judgment, page 179. The Supreme Court identified three sources of the court's power to grant civil proceedings. One, inherent jurisdiction. That is to say that the court possesses inherent authority to prevent injustice and preserve judicial process. So it's inherent. It's not conferred by any particular law, but by existence of the court, it has that inherent power to prevent injustice and preserve judicial process. And two, rules of court. So CI 47, there are a number of instances in which it may warrant the granting of stay proceedings. CI 19 has the Court of Appeal rules, or CI 16 Supreme Court rules. Then statutory provisions, apart from the rules of court, they also have a specific statutes. So some statutes expressly authorize sale of proceedings, particularly when it comes to, let's say, the ADR Act, arbitration statutes. What principles govern sale of proceedings? One, there must be a pending appeal. There must be a pending appeal. A stay cannot exist without a pending appeal. Now we are talking about appeals, so that's why we're saying that. So where you haven't filed notice of appeal, let's say that interlocutory decision has been made. You haven't filed a valid notice of appeal, and yet you have brought a motion application with stay of what? Proceedings. What are you seeking to stay? The application becomes incompetent, isn't it? So notice of appeal must have been filed, or leave to appeal must have been sought where leave is required. 2, the appeal must be competent and agreeable. The applicant must demonstrate substantial grounds of appeal, agreeable issues of law, and genuine appellate questions. So therefore, the court will refuse stay of proceedings where appeal is frivolous, or vexatious or an abuse of process, as you know. But let's note that the applicant need not prove probable success. He doesn't need to prove that the appeal will be successful. He only needs to prove there's an arguable what? Appeal. There's an arguable appeal. And when we say arguable appeal, the court will examine whether the grounds will lead to the decision appeal against. If you look at the grounds of appeal, if you read the judgment or decisions, do the grounds actually relate to it? Whether leave is required, for example, if leave was necessary, and whether the particular support the grounds. Sometimes you're supposed to give out the particulars of error. If you are talking about error of law made, I'm supposed to set out the particulars. The particulars which you set out, do they support the grounds? And whether the appeal attacks concurrent findings, as the case may be. So all manner of things. Then 3, exceptional circumstances must exist. Exceptional circumstances must exist. And this is the controlling principle. This is the heart of the matter. And when you come to the court of appeal, that is the mantra. Are there exceptional circumstances? If you cannot show exceptional circumstances, then you throw you through the window. So the court insists that sale proceedings should only be granted in exceptional circumstances. And this will include 1, jurisdictional challenge. Maybe where appeal raises serious jurisdictional issue. For example, you are saying that there's probably like a breach of natural justice because there was not a proof of what? Service. Or some other thing. Or the court even didn't have jurisdiction, as the case may be. Or 2, exceptional circumstances will include maybe destruction of the subject matter, where the rest, that is the subject matter, may be irretrievably destroyed before appeal determination. That if the stay is not granted, the subject matter may be destroyed. And when it is so destroyed, nothing can be done after the appeal. 3, irreparable prejudice. That is where continuation of proceedings may render the appeal nugatory. If, for example, the stay of proceeding is not granted, and appeal continues. At the end of the appeal, if the appeal is successful, the proceedings may be rendered negative, like maybe there'll be no point, as it were. Or sometimes there may be unfair prejudice, which can even be repaired. So let's suppose that somebody wanted to amend statement of defense. Just like I think I gave you, is it AFSA table something, a case like that. Did you read it? You didn't read it. On amendment of the system. I gave you a court of appeal judgment to read. Did you read? AFSA tables, you don't remember? Praise the Lord. You didn't read, okay, that's good. It's on the system, but there's an aspect which is very important that which you ought to have read. So there have been series of amendments, and the defendant brought application for amendment again. Then the trial court refused, and he sought to appeal. So eventually the appeal was successful. So let's suppose that the trial court had ignored or had refused an application for stay of proceedings, and it was not necessarily repeated, or no proceeding was granted, but the trial has gone on. And then it was up to address it. Now here is the case. The appeal has been successful. Now they need to go back and reverse everything up to that point where the amendment ought to have been made. So you can imagine how murky the situation will be. So that is the kind of thing we are talking about. So apart from exceptional circumstances, we cannot exhaust them. Exceptional circumstances, we cannot, these are just examples. Another consideration, the balance of hardship. The court balances hardship to the applicant, if refused, against hardship to the respondent if granted. So if the self-proceeding is refused, would the applicant suffer more than the respondent? So the court is reluctant to grant self-proceedings where it will unnecessarily delay justice or to frustrate speedy trial. But one thing you know is that it's discretionary, isn't it? It's discretionary, meaning there's not something that you can get as a matter of course. You need to convince the court. And that is why when you're putting your application together, you have to assemble the facts and documentary support, which will convince the court that this is a deserving case for granting a stay of what? Proceedings. So when will the court refuse self-proceedings? One, where proceedings are at advanced stage. Let's say that the proceeding are at advanced stage, and what you are trying to appeal, when it's considered, is really going to be inconsequential. Or where the application is merely tactical. If we review the whole course of the conduct of a party is just trying to cut corners in order to delay or frustrate the trial. Or where the appeal is weak or frivolous, you look at the grounds of appeal and you read the whole thing, you see that no, this appeal is weak. Or sometimes delay may be the true purpose of the application. So if the court can see that the motive or the real reason for bringing this application for self-proceedings is to achieve a delay for delay's sake, then the court will refuse the grant. Of course, you know order one, the need for speedy what? Justice, avoidance of unnecessary delay, and so on. What about stay of execution? Stay of execution as opposed to stay of what? Proceedings. I think they are like twins. But twins which are not, they are Siamese twins, more or less. Yes. So stay of execution means suspension of the enforcement of a judgment pending appeal. Suspension of the enforcement of a judgment pending appeal. So if you look at the Black's Law Dictionary, to say that stay of execution is postponement, suspension, or halting of execution. So they're all the same. Now, stay of execution is not attacking the judgment. The judgment is valid, except that the enforcement is put on hold. It's put in abeyance or suspended. And appeal itself does not operate as a stay. So, and this principle holds true whether you are talking about the Supreme Court, Court of Appeal, or High Court. In exercising the appellate jurisdiction, when an appeal is filed, that by itself does not operate as a stay. A stay must specifically be sought and obtained. So let's keep that in mind. If you look at the CI 16, Rule 21 of the Supreme Court rules, that point is there. Equivalent provision in the CI 19 and then the CI 47. So the basic principle is that the mere filing of appeal or commencing appeal does not put the judgment, which is appeal against, on hold. No. So if you file appeal and you don't file for stay of execution, you can pursue the appeal all right, but the victorious party wants to continue the execution processes. So what is the object of stay of execution? The main objective is preservation of the subject matter, prevention of appeal being rendered nugatory, maintaining the status quo ante, and balancing competing interests. So what the law seeks to do is to strike a balance between the appellant's right of appeal on one hand, that is the losing party, and the respondent's right to enjoy fruits of judgment. Yes, you have won the case. You're entitled to enjoy the fruits of your judgment. At the same time, if someone genuinely feels aggrieved that the judgment is wrong or the judgment can be challenged, we shouldn't stand in the way of that person. So these competing interests, how to strike a healthy balance. That is how the law is actually structured. So similar to stay of proceedings, the principal governing stay of execution are: one, there must be a valid appeal. So without a valid appeal, of course, we are not talking about, there are other situations where you can have stay of execution. When we are dealing with, you remember that, other instances outside appeal where you can have stay of execution. When we're discussing the execution of judgments. Anyway, we'll look at your law. Two, exceptional or special circumstances. So the applicant for self-execution must disclose exceptional circumstances. Sometimes others will use the language special circumstances. They all mean the same thing. And a case which is well known by every student of the law as far as self-execution is concerned, the case of Joseph and Jabili. Joseph and Jabili, 1963, 1 Ghana Law Report 37. Chief Justice Akufo-Addo, he gave a very interesting judgment regarding the principle which will govern the stay of execution, but especially when it comes to monetary judgment. So I want all of you to read that judgment. Joseph and Jabili, 1963, 1 Ghana Law Report 37. Joseph and Jabili. Jabili is a Ghanaian name. So following my professor's, Professor Kumado's style, you have to learn how to spell it yourself. So the exceptional circumstances include appeal will be rendered negative, read Joseph and Javelin. Two, subject matter will be destroyed, just like what we saw in the stay of proceedings. And then irreparable harm will occur. The status quo cannot be restored. And again, the balance of hardship is another factor. So apart from the exceptional circumstances, balance of hardship, the court will examine who suffers greater hardship. If the execution is stayed, who is going to suffer most? Is this the respondent or the applicant? The respondent is the winning party, and the applicant is the appellant, the losing party. Who will suffer most? The court will also examine whether refusal causes irreparable injustice. If stay is not granted and the execution continues and then appeal also continues, will there be a difficulty which will be created, assuming the appeal is successful, which cannot be remedied? So look at the case of Jokoto and Emisa. Jokoto and Emisa against BBC Industrials Company Ghana Limited. Jokoto and Emisa against BBC Industrials Company Ghana Limited. 2011 to Supreme Court Ghana Law Report 625. The fourth point is that appeal must raise arguable points. Appeal must raise arguable points. And what do you mean by that? That is to say that the appeal must not be frivolous. We have to look at the grounds for appeal. It doesn't mean you should prove that the appeal is definitely successful. No. So if you can raise substantial legal issues, that would enhance the likelihood of stay being granted. So, and that is why, though you are not, of course, you still get there. When you are getting your application, you have to actually pay attention to if there's any substantial legal issue from the ground and also judgment, which will actually let the courts consider the application know that no, there's something serious at stake. So let us grant the stay. We need to emphasize that. What is the effect of stay of execution? So when it's granted, of course, when a stay is filed, it operates as a grant. When you are served with the stay, you cannot go ahead and be executing the judgment. That will be contempt of what? Contempt of court. Just as if you are served with the injunction, wishing for application for injunction or application for injunction, you cannot be doing the very thing application is seeking to restrain you. That was a contempt of what? Of court.
This debate is about being served and then the notice of injunction being pursued. There have always been that debate about.
No, if there's a pending application, also known as a motion, if there's a pending motion for injunction, and you are the party, you are the respondent, you have served you. Once you are served, you are the known. So you have to wait, stop everything, and let the court determine the motion. If you are served and you behave as if you've not been served and you are still going about life, business as usual, if it amounts to contumacious behavior, as like defying the court, then you have brought yourself within contempt. Yes.
Service of
Can you speak up so that I can hear you? Service, yeah. The motion or the application, yeah, they are the same, yeah.
So on acts.
Yes, it does. My lord. My lord, I'm teaching you how to survive. Your classroom is right and you have a fee. Sorry. Yes, so if I understood you, the question was, if you are served with an application, does it serve as a stay until it has been heard and determined? When you are served, it serves as a stay. It serves as a stay. At least during pending the, but the fact that it's serving doesn't mean that it will be granted. It may not be granted. And that is why those who indulge in the shortcut and then the rough play, sometimes the person has filed the stay. He knows that when the application comes to be considered on merit, it will be refused. But so you file it, and on the day which the matter is supposed to come on, you will not come to court. And then there are some bad things. I don't need to speak to it. Some of you will learn. Some are so evil that they'll go to the extent of even getting to arrange with the bailiff who is coming to serve them and tell the bailiff that just send it back, that you couldn't serve. So the bailiff will bring it back and fill affidavit on service. So when the return date, when the no, let's say that it has been served, but let's say hearing notice. Yes, so the hearing notice, you arrange that, say that you couldn't serve the applicant, or as it were. So when the court is not in court, automatically it will be adjourned. And the thing about the Court of Appeal is that, unlike the trial court, where it's the same judge, you can even adjourn to the next day. The Court of Appeal is a panel. So and the panel usually set Monday to Wednesday. So if it cannot be dealt with, it's adjourned sine die until it's put before another panel, which may be soon or it may take a long time. Then you are still benefiting from the stay because the application is what is pending. So that is what they do. But as I said, it's evil. So don't learn learn the good and learn the good things. Yes.
In your practice, what did you do? When you were practicing.
It's privilege. I think my lawyers will invoke the privilege. So I'm excused from answering your question. Okay, so there's, in terms of stay of execution, there used to be this concept of executable and non-executable judgments. And that distinction was said to be critical. So traditionally, the view used to be held that stay only applies to executable judgments. When we say executable judgments, that is a judgment which can be enforced using any known tools or mechanisms of what? Execution. And for that matter, declaratory judgments cannot usually be stayed. Like declaratory judgment by itself. The reason being that it's not executable. So there used to be those cases. Let's look at the case of a boy and a bow. And this is the one Ghana law report 432. The case a boy and a boy, or a boy and a bow. And then Musi and Bajina. Musi and Bajina, we know that case very well because of order what? Order 81, L and orders. The old L and 140 order what? 770. And then look at the Standard Bank of West Africa against Boite, 1971, 2JLR 231 Then C, Mensah against Ghana Football Association. 1989-90, one Ghana law report. But in recent time, the Supreme Court has adopted a very purposive approach, meaning that the distinction of executable and non-executable is not important. If you remember the case of the Oji-Idom, remember that case? Oji-Idom, no, Oji-Idom, is it the Berima? Oh, you don't follow the legal front.
It's the central region
Yes.
where they were talking about there was a case in court that the lawyer actually took some money from.
Yes. So if you look at the current trend of cases, the distinction between executable and non-executable is blurred. And for example, if you take the Standard Chartered Bank against Western Hardwood, 2009, Supreme Court Ghana Law Report 196, Atukuba GSC, or for example, remind us that proceedings may include steps necessitated by a judgment appeal from. For that matter, in exceptional cases, even non-executable decision may justify protective orders. So what ordinarily have been treated as non-executable, in exceptional cases may warrant protective orders like either suspension of, now they introduce those concepts, that if you are not staying, you can suspend the judgment. Just an attempt to try and avoid the distinction between executable and non-executable. It's also possible to have what you call the post-judgment injunction. So apart from stay, you can also have a post-judgment injunction. So also look at the most modern trend, as we see in the Merchant Bank Ghana Limited against Similar Ways Limited. Merchant Bank Ghana Limited against Similar Ways Limited. 2012, 1 Supreme Court Ghana Law Report 440. One more point to note is that stay of execution may be granted conditionally or on terms. If I say conditionally on terms, it simply means that, yes, the court is staying execution of the judgment, but on certain conditions. For example, that maybe if it's a money judgment, that the percentage of it should be what? Should be paid. Or the money, if the concern is that if the winning party is allowed to get the money and the appeal is successful, you will not be able to pay the money. Okay, the court will say that if that is a concern, then will not let the winning party get access to the money. Put the money at a neutral ground. So give it to the register of the court for you to be deposited in the interest holding account, pending the outcome of the appeal. So if your concern is that the winning part, the respondent will not be able to pay, we still grant the stay, but bring the money here. We not give it to the respondent. So that is one. Or sometimes the court may order provision of security. The stay is going to be granted. But what about if at the end of the appeal, you lose the appeal? Your appeal may take 2 years or a year, 3 years. You have prevented the winning party. And you might have suffered so many inconveniences. So provide security that we're able to take care of whatever lawsuits will suffer due to the stay. The fact that he is not allowed to implement what the judgment, should you fail in the appeal, as it were. So read Joseph Jebili, as I said. But poverty alone is generally insufficient as a ground for self-execution. You can't go to court and say that, my lord, life has become so unbearable. So can you stay? No, this no. It's not. It's not like that. Now, the other point to note is about the fact that the stay of execution must always be brought in the court below first. And let's get this thing right. A lot of lawyers keep making that mistake. So we've said that a valid appeal notice might have been filed in the court below. Then you bring application for stay of execution in the court below. If the court below refuses it, that it throws out the application, does not grant it. Because the record of appeal will not have been transmitted to the appellate court, you can repeat the application in the appellate court. You don't need to have the record transmitted before you can repeat. So you repeat in the appellate court, and then when you repeat the application, you have to exhibit the initial application which was refused, the decision. You exhibit it to the repeat application for the appellate court to look at it. But if a grant is made and the grant is on terms and the terms are harsh, it's interpreted as a refusal. So if a grant is made and then it's made on terms and you think that the terms are hard, that's interpreted as a refusal, and that you can repeat the application at the appellate court as it were.
That is a grant at the court below.
Yes. Now, so just to leave this aspect for our discussion, in terms of the key distinction between stay of proceedings and the stay of execution, of course, that could be a short examination question, isn't it? Discuss the differences and similarities between stay of proceedings and stay of what? Execution. So stay of proceedings, as we have noted, it halts or it stops ongoing litigation or it suspended. But stay of execution, on the other hand, halts enforcement of what? Judgment. Now, stay of proceedings is usually before final judgment. It's usually before what? Final judgment. Stay of execution is usually after final judgment. Now, stay of proceedings prevents further procedural steps, that no further procedural steps should be taken in the case when the stay of proceedings is granted. And then stay of execution prevents execution processes from being deployed. So as we can see, stay of proceedings focuses on pending proceedings. And then stay of execution focuses on the enforcement of execution machinery, as it were. So we will give ourselves just a 2 minutes stretch, and then we'll discuss costs, and then money lenders action.
Well,